So friends, when it comes to legal challenges, court challenges against Donald Trump and his corrupt executive branch cabal, Trump is far and away the biggest loser in court. And when it comes to judicial opinions delivering those losses to Donald Trump, there are strongly worded opinions, there are scorched earth opinions, and then there are opinions like the one just issued by Judge Patrick Schiltz, who happens to have been appointed to the federal bench by President George. This Justice Matters video today might have a bit of a Schoolhouse Rock feel to it, but we're not going to talk about how a bill becomes law. We're going to talk about some of the basics of grand jury investigations and grand jury subpoenas. Now, I'm probably not going to tell you anything you don't already know. But when a crime is committed and prosecutors want to investigate that crime to try to identify a perpetrator, maybe try to indict somebody, hold somebody accountable for the crime, what we do is we open a grand jury and we issue grand jury subpoenas. And those subpoenas have the force of law, requiring a witness who receives the subpoena to appear before the grand jury and testify truthfully about what he or she knows. Or sometimes we issue subpoenas for documents or for certain evidence. But when it comes to prosecutors issuing grand jury subpoenas, we have almost free rein, right? Our discretion is extraordinarily broad. The only thing we can't do is use grand jury subpoenas for an improper purpose, like if a prosecutor has some beef with a personal enemy of his or hers, and they want to abuse the grand jury subpoena process by subpoenaing that person, not for a legitimate reason, not to investigate crime, but to harass them, that would be an improper purpose. If the Attorney General has a personal enemy that he wants to hassle or harass or intimidate, and he has his flunky U.S. attorneys issue a grand jury subpoena to harass a personal enemy, that would be an improper purpose. And goodness knows, if a president of the United States has a personal enemy, a political foe, and he wants that person intimidated, harassed, punished, and he had his flunky acting attorney general and flunky U.S. attorneys go after his political foes, his opponents, his perceived enemies with grand jury subpoenas, that would be an improper use of a grand jury subpoena. Friends, I worked for the largest United States Attorney's office that the Department of Justice has to offer, the District of Columbia U.S. Attorney's Office. And in my decades there, working together with about 325 to 350 federal prosecutors at a time, not once did I know of a grand jury subpoena being struck down because some prosecutor issued it for an improper purpose. Well, guess what? A series of subpoenas issued by one of Donald Trump and Todd Blanche's flunky U.S. attorneys was just struck down. And it was struck down in spectacular fashion. So let's start with some great reporting from Politico, and then we'll talk about a few main takeaways from this legal development that is crushing to Donald Trump's dirty Department of Justice leadership. And this headline starts with a quote from a federal judge who was appointed to the bench by President George W. Bush. Quote, "Blatantly unlawful," close quote. Judge blocks DOJ subpoenas aimed at Tim Walz. Judge Patrick Schiltz said the grand jury subpoenas were no doubt aimed at punishing Walz for refusing to aid immigration crackdown. A federal judge has thrown out Justice Department grand jury subpoenas aimed at Minnesota Governor Tim Walz and his allies, calling them an abusive and retaliatory process to punish Walz based on his refusal to assist President Donald Trump's immigration crackdown. In a blistering ruling, U.S. District Judge Patrick Schiltz said there was no doubt that the subpoenas were issued to damage Walz. Part of what he said was a pattern of Trump administration efforts to use criminal process to punish the president's adversaries. This from Judge Schultz, quote, "Initiating a criminal investigation in order to harass political opponents or to coerce them into taking official action, particularly official action that the federal government cannot directly require those political opponents to take, is a blatantly unlawful and unethical use of the grand jury process, Judge Schiltz wrote in a 29-page ruling dated June 17, but unsealed Monday. The George W. Bush-appointed chief judge said Trump's repeated attacks and promises of retribution against Walz, a Democrat, and other Minnesota officials establishes beyond reasonable dispute that the grand jury subpoenas issued at the height of ICE's Operation Metro Surge were a part of a broader campaign to coerce state and local officials in Minnesota to assist the Trump administration in its enforcement of immigration laws. The federal government is barred by the Constitution from forcing states to enforce federal laws, Schiltz added. Moreover, Schiltz linked the subpoenas to what he called the Trump administration's well-established history of using criminal investigations to retaliate against and pressure the president's political and personal adversaries. Judge Schiltz pointed to the recent investigation of Federal Reserve Chair Jay Powell, in which another federal judge similarly quashed subpoenas on the grounds that they were retaliatory. The ruling rejects 6 grand jury subpoenas that federal prosecutors targeted at Walz, the mayors of Minneapolis and St. Paul, the Minnesota Attorney General, and commissioners of Hennepin and Ramsey counties. The subpoenas were issued at the height of Operation Metro Surge, in which thousands of federal agents descended on the Twin Cities to enforce Trump's mass deportation agenda. The enforcement surge led to tense protests by local residents, 2 of whom, Renee Good and Alex Preddy, were killed by federal agents during confrontations on the street. Their deaths drew national attention to the administration's crackdown and presaged a sharp decline in public support for his immigration agenda. Judge Schiltz said the subpoenas were extraordinarily broad and sought materials related to constitutionally protected conduct. And he said DOJ's efforts to connect those materials to any potential criminal activity were strained at best. Quote, "The fact that connections between the information sought in the subpoenas and any possible criminal violations range from extremely weak to non-existent, and only adds to the overwhelming evidence that these subpoenas were not issued to investigate, but to harass, coerce, and retaliate," the judge concluded. So friends, like I said, there are strongly worded judicial opinions, there are scorched earth judicial opinions, and then there are opinions like the one Judge Schiltz just authored, which has a bit of a, "are you effing kidding me?" feel to it. You know, I think I want to stick with just one main takeaway, and that is this. Everyone involved in this corrupt endeavor, from the acting attorney general to the flunky U.S. attorney to any federal prosecutor unethical enough to associate themselves with this horrific abuse of prosecutorial power, every last one of them needs to, 1, be referred to their state bar, the state in which they hold their license to practice law, for an investigation into this obviously unethical conduct. And depending on the result of that investigation, they should be on the receiving end of sanctions up to and including permanent disbarment. And 2, come January 2029, when the rule of law comes back into the light of day, all of these people who so horrifically abused prosecutorial power to do dear leaders' corrupt bidding